I'm talking on a cell phone. We've lost our electricity and our internet at our NRB office in Montpelier. Power's out. So you'll hear a fire alarm going on in the back. That's gone off as well. So we're working on that. But in the meantime, because we have so many people, I want to continue the meeting, and I apologize for the inconvenience. With that, I can't see any of you. I'm going to ask that we pick up where we left off when we blinked out. And I believe that one of the members of the public was going to begin and start your presentations. So please go ahead.
Can you hear me?
Yes.
Hello?
Yes, we can hear you.
Okay, my name is Tracy Porter. I live in Danby, Vermont on South Main Street, across from Fuller Sand and Gravel. And he was granted a Act 250 permit about 11, 12 or more years ago to reopen a closed pit. And ever since then, our lives have been miserable here in the village of Danby. We are inundated with all kinds of dust. The smell from the asphalt plant starts shortly after 4 a.m. in the morning and continues all day. He's permitted for 30 to 60 trucks to go in and out every day. So all day we have Jake brakes, backup beepers, shifting trucks, and that's not including the noise from the pit itself. The rock crusher, the asphalt plant running, the triaxles, the excavators, all the equipment. It's come to the point you can't open your windows, you can't, or you get covered with dust. The noise is horrendous, and the worst part of it is the blasting. He's permitted 10 blasts a year, and each blast shakes my house. He's done damage to not only my house, but other people's houses around the pit. And Act 250, myself and a lot of other people in the town around the pit have contacted them about all these violations, and it doesn't seem like anything's ever done. He just continues. Most of us weren't even aware there was going to be a pit up there until after the fact, after he had already gotten the permit. And people have left town because of it. If I could afford it, I would move. It's unlivable. Our quality of life has gone down. There's no peace and quiet. There's no clean air. It's horrendous, and I don't understand why Act 250 allowed a pit to open in the middle of a village where, all this is going to affect all these people. And I guess that's all I want to say. It's like, please, I beg you, do something. Thank you.
Thank you. So let's turn to the next speaker, please.
Hi, I guess that's me. I can totally relate to the previous caller. My name's Lori Bernier. I live in the villages of Graniteville and Berrytown. I bought my property and moved back to Graniteville after living elsewhere for approximately a year and a half. My hope was to recapture the serenity I grew up with. But now, since the asphalt crusher operations are here, it's like a nightmare. The noise starts early in the morning, often waking me and my family, and it doesn't let up until the end of the workday. I find myself avoiding going outdoors and spending time due to the constant banging and clanging. There's just no peace. This has been going on for approximately 10 years now, since Northeast Materials Group asphalt and crusher operations were approved under their land use permits. Even as I sit here right now speaking to you, the noise is penetrating my house in the background. I can hear the noise in my home. There's been dust and odors and trucks over the years. The trucks are tremendous. I mean, the size and the amount of them are just unbearable, traveling through these little villages where people walk. And it's from morning till closing. I mean, there's just no peace 5 days a week. It's constant and it's consistent, and to me it's unacceptable and invades the privacy of our home. After receiving a visit from a friend recently and experienced what I do on a daily basis, his comment to me was that you cannot pay him to live here. To me, I think that statement alone speaks volumes, and it pretty well says and explains what it's like to live next to these types of industries. You know, that people wouldn't even want to live here. You couldn't even pay them to live here. My heart and soul are connected to my property. I was born here and I grew up here, next door, matter of fact. You know, why should I be expected to move and pick up and leave when I was the one who was robbed from my peace and quality of life? I didn't move in next to this industry. This industry moved in next to me. And it makes me really, really sad to think that I'll be subjected to this for the rest of my life, through my retirement years, you know, my golden years. You know, it's just not acceptable and it's wrong. I think the only way citizens can truly be helped is if the NRB is willing to take the steps to seriously step back and examine what's going on and take the constructive criticism that people are giving here today and actually act to make the changes needed to protect citizens against improperly cited industry. Or at least when a business is placed, it be effectively mitigated against negative impacts and have enforceable permit conditions. And that's the key word, enforce. Unfortunately, that has not happened for us here throughout the 10 years. Enforcement has been non-existent, and not helpful at all. I think in Graniteville, we had a unique situation where we were fortunate enough to have an engaged district commission in hearing our case on the crusher plant. It consisted of an engineer, an attorney, and an environmental worker. I feel this was a diverse group of knowledge to objectively look at the details that it takes and necessary to review a case like this. Because of this, I think that we effectively provided evidence, and we succeeded to not only rebut the presumption of the ANR air pollution control permit, which is basically unheard of. We were also successful in having the permit application denied. And that leads to a couple of the problems. One, in that there is a lack of training in our district commissions. We were lucky to have an experienced commission, but all too often in recent years, I don't believe the district commissions are qualified and trained with the knowledge it takes to objectively hear many of these cases. They don't have the experience, they haven't lived near them, they don't even know what it's like. It can be done, and it has been done in the past, which is evident in many past environmental board precedents and subsequent district commission decisions that were denied, and where identified impacts were mitigated and effectively done so by appropriate permit conditions. Just look back, we can learn from these cases, they're there. I know they're there because we use them effectively in citing parts of our case. And then I think another problem, one of the biggest in my eyes, is the applicant being denied the permit and then appealed in the environmental court. At this point, the NRB should have stood up behind and supported the district commission's decision and represented that position before the environmental court to uphold that decision. This is their own agency. Rather, the NRB did absolutely nothing. They did nothing for us. In fact, they didn't even remain neutral. They took the side of the applicant and just adopting the attitude in the administration's lead of all business is good. And, you know, that's just not the case. There's many businesses that should not be cited. The NRB failed. They failed in effectively and adequately use and take advantage of their position as a party to the appeal in representing the interest of the public and safeguarding the health and safety of citizens under the criterion of Act 250. There is no doubt hearing what people are dealing with and living in industries like this is very important and should be given great attention, the attention it deserves. But until the NRB, in ensuring businesses paid it appropriately, are denied approval if undue or unreasonable impacts are determined under the criteria, you're all going to be hearing more people come in front of you, as I am and the others are here today, indefinitely. So I think in saying that, I hope that you hear what we all have to say and act upon it and take it seriously rather than just filing it away, because it doesn't help residents at that point. We end up losing our quality of life and what we worked hard for. Thank you.
Thank you, Ms. Bernier, and thank you, Ms. Porter. And I do want to be clear that it is important to us that we hear your input, and we appreciate your input. And for the rest of the speakers, my ask is that we try to limit your comments to 2 or 3 minutes so that we have an opportunity to listen to all of you and to conduct the business that we have to conduct today, if that's possible. And I know you all are trying to be direct and concise, and your comments have been very appropriate. But it is important that we try to keep this meeting as efficient as we can, and I know you share that view. So thank you as we go forward. Who is the next speaker, please?
Is it me?
Mimi, yes, go ahead.
Who is?
Okay, this is Mimi Aoun. Can you hear me?
Yes.
Okay. Hi, my name is Mimi Aoun. I own and I reside in a farmhouse located at 724 Delano Road in Albany, Vermont since 2012. My property abuts the Albany town sand and gravel pit, and we share a common property boundary of over 1,650 feet. Delano Road bisects my property for over 1,500 feet, and my house sits 37 feet back from the road. Town trucks travel back and forth over Delano Road to haul sand and gravel to the town storage garage a couple miles up the hill and to maintain town roads. I am here to describe how the operation of the pit impacts my quality of life and my negative experience with the Vermont Act 250 regulatory system, with ongoing proceedings of the Town of Albany's application 7R1042-2 for a 20-year extension of their current permit, which is supposed to expire in 2023. Over the past 9.5 years, the Town of Albany has repeatedly violated several conditions of the Act 250 permit, including specific restrictions on extraction volumes, limits on screening and crushing, and exceeded their permitted 2-week period continuous hauling of sand and gravel. I have experienced firsthand the detrimental effects on my health, my safety, and my overall well-being, as well as the quiet enjoyment of my property. The worst impacts are from the heavy truck traffic during the month of May through August. Those repeated violations led to further exacerbating the hardship I have experienced. Excessive and unhealthy dust exhaust. When the trucks pass by, they create huge clouds of airborne dust and emit diesel exhaust that pollutes the air and permeates my house, settling on all surfaces. This hauling operation lasts from 7 a.m. till 5:30, with trucks traveling through my property every 4 to 8 minutes, depending if 2 or 3 trucks are being used. I suffered severe eye irritation, chronic nosebleeds, and severe headache due to the dust and rumbling truck noise. This required me to seek medical assistance and prescription medication for some relief. During hauling operations, especially during dry conditions, the town does not even apply sodium chloride to mitigate the impact of the dust. When I asked about it, they said sodium chloride is too expensive. Traffic and congestion. Another impact is the traffic congestion this creates on a town dirt road, causing a major safety hazard for myself as I regularly travel along and across the road to the other side of my property. I I was informed during the select board meeting the speed limit on Delano is 50 miles per hour, and reducing speed will only lengthen the haul time. I suggested a state highway such as Route 14 to be used for such hauling activity, not Delano Road. In addition, vibration from passing trucks have caused cracks in my stone foundation. I have gone as far to hire a engineering firm to assess actual short and long-term damage. Basically, given the excessive airborne dust and traffic, I am a prisoner in my own home during the most beautiful time of the year, and my only choice is to abandon my home to avoid such adverse conditions. Permit reclamation plan. The town has failed to implement its extraction and reclamation plan, resulting in substantially greater exposure of the open pit face, exacerbating the adverse impacts on aesthetic values and also increasing airborne dust. This goes beyond aesthetic. It is offensive to the scenic and natural beauty of this area and affects the enjoyment of my property. I recently updated my 10-year Vermont forest management plan, and the property has many trails, an active creek, and supports plenty wildlife. On more than one occasion, I reached out to the Act 250 District 7 Commission seeking their guidance or assistance to my concerns and lack of response from the town. The response was their function was to issue Act 250 permits, not to enforcement. Basically, to put it simply, we are not the police. I was frustrated, to say the least. It wasn't until 2017 that I learned from the District 7 Commission that there was an NRB enforcement agency that could help me with enforcement of the permit. I reached out to them, but was told that unless I have extensive evidence, they could not help me. Discouraged and shocked by this indifference, I resigned myself to be patient, hoping things would somehow improve, and looked forward to the expiration date of the Act 250 on December 2023. In 2018, I learned that the town is planning on applying for a 10-year and then amended 8 months later to a 20-year extension permit with added 24/7 operating hours. I went to a select board meeting to discuss this new turn of events prior to the town turning its application. The select board said something to the effect, that is what we are planning on doing. I am the one leading this project, and you will get your say once the application is in the hands of the district commission. It was clear there was no room for a dialogue, input, nor inclusion. This attitude is consistent with the way this particular select board operates toward myself and other concerned residents, hostile, dismissive, and even bullish during some meetings. In February 2020, my council submitted a detailed 120-page report to the NRB enforcement and compliance officer, documenting numerous permit violations, too expansive to get into here, photos and video clips taken by me between 2016 and 2020, showing the blatant disregard to any dust mitigation efforts during this hauling season. It took the enforcement and compliance officer almost 9 months to finally issue an OF to the town of Albany, asserting violations of conditions of land use permits 7R1042 and 7R1042-1. My council then filed the petition to stay so that NRB enforcement has the necessary time to thoroughly investigate and ensure compliance moving forward. The petition was ultimately denied by the district commission, despite the fact that the town's violations were current and ongoing. The compliance evidence was substantial, and given the sheer scope of its revised permit application submitted October 2020, once the NOAV was released, the Albany Select Board contended that the NOAV or its compliance will be rendered moot or inapplicable, or that the violation be cured as a result of its permit amendment. This is disingenuous and unsupportable, and further demonstrate how the Albany Select Board handles things. Unfortunately, I did not have the opportunity to address this assertion as my council suddenly deathly ill with cancer, passing away shortly thereafter. I contacted the enforcement agency multiple times through voice and email, expressing my concern over the NOAV status and to learn what were the next steps toward enforcement. They refused to reply to me. I was forced to secure replacement counsel on short notice. All the while, the commission and the town kept pushing for scheduling the hearing on the permit extension. Not until I hired new counsel did I learn that the NRB issued a letter on April 21st while my counsel was dying in the hospital, that stated even though they agreed the town had committed permit violations, their decision was not to take any enforcement action. To me, this response is simply a slap on the hand, essentially saying to the town, you've been bad, you should follow the permit condition and be better in the future as far as a record keeping. No penalties, no repercussions, no enforcement in regard to the, to the hardship this operation has had on my welfare. Unfortunately, this can only further jeopardize the public's faith in Act 250. In short, the action or inaction of the NRB enforcement agency goes against the core values Act 250 seeks to protect: promotion of conservation of forests and natural areas, protection from polluted air and water, the public's rightful expectations that conditions of a permit have real meaning and will be enforced. This has been a long, frustrating, mentally exhausting, and expensive legal process for me with nothing to show for it. To say the NRB enforcement agency and the Act 250 process, oh my God, I'm sorry. To say that the NRB enforcement agency and the Act 250 process has failed me on many levels is a gross understatement. Thank you for your time.
Thank you, Ms. Allen.
Can you hear me?
Yes.
Hi, everyone. Thank you for making some time for us today. I'll try to make this quick. I am Emily Johnson, a Pollitt resident, a local Vermonter with a passion for what the state has to offer. My fiance, Matt Corey, and I moved to Pollitt from Castleton in the summer of 2018. We love this area of the state for many reasons, but a few of them being the calm back home feel, the picturesquely restored farmhouses, locavore lifestyle, and the never-ending charm of the neighboring lush green mountains surrounding us. We've spent time and money to make our house an efficient home and making our property a place to sit outside peacefully and take in all the great outdoors that Vermont has to offer. Unfortunately, some of the calm and content from our lives has dissipated. About a year ago, the neighboring gravel pit, unknowingly at the time, opened the face of the pit to the west of our property. It opened up a funnel to blow fine particulate dust anytime the wind blows. This dust has encroached on nearly every inch of our property. If you're outside when it's happening, you can feel it crunch between your teeth. This continued through the winter, coating every snowfall with a sandy shade of dirt. Fast forward to this spring. After what felt like some convincing, we were finally able to get some representatives to visit our property from 250 and Air Quality Division. We have been documenting the dust issues via photos and videos. Videos that show sandstorms rolling off the hill and swallowing all of the green lush and everything else standing on our property. This is the documentation that convinced these folks to come and assess the situation. The operator of the pit was issued 8 compliance directives with deadlines, the most impactful and important one to us being the mitigation of dust coming onto our property. This had an immediate deadline issued on July 6th, stating, must immediately take action to prevent windblown dust or dust from crushing and screening activities from drifting off the Robley Farm quarry property and onto the quarry property. Actions include, but may not be limited to, reclaiming portions of the quarry where the dust is being generated by regrading and seeding or application of water, calcium chloride as dust control measures. So let's fast forward to just a couple weeks ago, September 6th. As the leaves begin to thin with anticipation for fall, we're once again inundated with a sandstorm, which has also been documented. We have had promises from the state support about these issues and how it's unacceptable. We've also been told we're low on the priority list and there's bigger fish to fry, essentially. The one coming to fruition feels to be the latter. This state totes their commitment to clean living. If this is of any indication, how are these issues still not resolved? Why are our names able to be disclosed to a multiple time violator for reporting clear violations impacting our health? For those of you who don't know what it is, please research silicosis if you haven't already. But these violators, they're giving a heads up as to when their next compliance visit is. The measures in place seem to be nothing more than a farce. Entirely too frequently, I am reading reports of other folks throughout the state with similar and more severe issues. Rocks coming through residences' roofs. How are these issues not being covered with such a force that proves our state's commitment to the people, their health, and safety, that they care, they matter, and they're safe? We don't need to become victims of a freak accident or an irreversible detriment to our health from someone else's negligence. Where is the accountability, the follow through, the passion? Most businesses operate under a safety first motto, safety above all. When will this state operate under that assumption? When will this state have guidelines in effect to protect our health and safety? When will we be more than something more than just people who pay taxes? Thank you.
Thank you, Ms. Johnson. We have another speaker.
I believe I may be next, Mike Wesco.
Hey, Mike, thank you.
Yes, my name is Mike Wesco. I'm also from Paulet, and I'm also a adjoining landowner, as Matt Corey and Emily Johnson are, to the Rob Lee Farm Incorporated Sand and Gravel operations. I believe all of the Act 250 enforcement and legal people that are part of this meeting today, which would be Aaron Brondike, Greg Bulbo, Michael Stickney, and Allison Stone, they all know me. Some of them for over 5 years, that I've been dealing with violation after violation, well documented, of the Rob Lee Farm Incorporated Sand and Gravel operations. The Quarries are new to this process in the last year. I have watched the sand and gravel operation over-excavate the stated limits of excavation on multiple phases and locations of their 300-acre tract. I have watched them encroach into my property, rip out trees, change original contours, and destroy vegetation. I've watched them do it on an adjoining neighbor's property in the same manner. They've also entered into a sensitive riparian natural area, possibly contaminating a natural spring outflow of an adjoining property. I've watched them bury stumps and tree-linked material in non-designated areas, possible contamination of groundwater. I have seen dust from the open exposed surfaces, of which are supposed to have erosion control methods in place according to the LUP and the criterion set forth. I have seen silty, turbid water on multiple occasions, complete with videos, pictures, and analysis, dump into the waters of the state and eventually reaching the Meadowy. All this has gone on for the last 5 years with almost no help from Act 250 enforcement. It is only recently that things have started to move in a direction where they may be forced into compliance. The core mission statement of the NRB prioritizes protecting the natural environment. With the amount of information and documentation, licensed state surveys, overviews, topographic markups that I have provided to enforcement, to be at this point in time is absolutely unacceptable. I have over 40 years experience in construction, dealing with landfills, Superfund sites, crushers, screens, engineers, consultants. So I'm not just here to have something to say that I feel negative about. I have been told that the operation has operated within its limits because the attorneys for the operation have said so, with no documentation provided to me, no written amendments to the original LUPs or criterion. The gross failure of qualitative, quantitative, objective review of this entire operation. And it's been going on since they have started. They were in violation within less than a year of their first permit status by doing illegal blasting, doing winter operations in wintering deer areas, so forth and so on. The backside to all this is that the town of Pollitt and neighboring towns purchased material from this pit. So, Vermont taxpayers are funding the operations of this sand and gravel pit, which is in violation of maybe all of their criterion and conditions set forth in their LUPs and their applications. It's unacceptable. I've shortened what I've had to say because I could probably speak for 3 hours for the rest of the days left in 2021 to say what I really have to say. I hope everybody hears this. Enough is enough already. Thank you.
Okay. Thank you, Mr. Wesco. Do we have another speaker?
Jane and Larry, go ahead. And this is our last speaker.
Okay, hopefully you can hear me.
Yes, we can. Thank you.
Okay, I don't even know where to start because we've had a lot of more serious issues than even these other people. Not that I don't feel for you because I do. I actually was hoping, Don, that you could have a little visual, and I'm going to start out quickly by telling you our address. It's 999 Blissville Road in Castleton. Okay, our house was built around 1778. That was back when the Declaration of Independence was signed. We moved here in 1992. It was a very quiet, peaceful area. We did realize there were quarries behind our house, but we were told that they were inactive and would not be opened again. I'm going to put this picture up so that hopefully you can see it. It shows our house. And you can see an area behind it where my husband's fingers are right here, where you can see it's just open. We have a greenhouse back here. Skip forward a couple years. This is what our property looks like. You can see the amount of rock, waste rock that was dumped behind our house. Okay, this forms like a mountain. So you can just imagine all the noise, dust, dirt, truck noise, beepers. And we haven't even gotten to the blasting yet. This blasting has gotten really crazy. We have had the rock fly out of the quarry on numerous times in 2003, 2006. Numerous times in between where it has landed on our property, hit houses across the road. It has cracked our foundation, cracked our sheetrocking in the house. And it has endangered our lives because numerous times we were out there. We have contacted everybody in the state, all the police, every representative, everybody in office. And this last time was in July 16th of this year. The rock landed in our yard. It went through a roof across the street from us and came through the floorboards in the attic and was hanging out on the second story ceiling. My husband's going to hold up a rock just to show you. This is one of the smaller rocks that landed, okay? We had a rock land almost, they said, with the trajectory, about a half mile away from the quarry. And as I showed you those pictures there, you can see how high that berm was. The quarry sits down below that, so you can imagine what force it took to blow that rock from inside the quarry up over that giant berm and out into the neighboring yards. And it landed probably about a foot. My husband had to duck. He heard rock whizzing over his head. And he can show you on this picture, it landed about a couple feet from where he was standing. And if he hadn't ducked, it probably would have hit him. This is another one that was close to it. Mind you, this rock flew out of the quarry, sheared apple tree branches off, hit the ground, took a 2 or 3 foot divot out of the soil where it peeled back the sod, landed, broke again apart, and then it hit 70 feet away from that, landed into our dog's fence, and then it shattered further after that, endangered our dog's life and my husband's life directly. We have it a foot away from our foundation and our electric box for the house, all throughout my garden, and hundreds of pieces all over my property. It landed on Blissville Road. If cars had been going by, people could have gotten killed. It landed out in yards where children were playing. And this is unacceptable. And I said, this quarry does not fall under Act 50 because of a little law, Act 30, which exempts quarries. It is slate quarries. It is the only entity in Vermont that does not fall under Act 250. Just for these safety issues alone, I mean, we shouldn't, our lives have been in danger here. We are terrified. They are supposed to be using whistles to go off before the blast. But even that, does that make any one of you people feel safe if you have a 3-minute window to run? And where are we supposed to run? Our house? We've already had rock come through the house across the street. I don't know what they are going to do, but I know something has to be done because, like I said, this has happened numerous times and everything has been documented. And there are laws in the town that should protect us, but because of Act 30, they don't fall under Act 250. But even now hearing about Act 250, I'm a little scared because I wonder where it is going to stop and what's going to have to be done to get these people to fall under the rules and regulations that are actually in effect and out there. Because they need to do something to enforce it. This is ridiculous. And we've also, as my husband's pointing out, we've also had trash and debris thrown, right over the hills, right behind our house, dumped while we're sitting there watching them do it, and we're filming. They have a blatant regard for any kind of rules and regulations, and something needs to be done. And I guess on that note, I'm going to leave it because I don't know what else to say.
Thank you, Jane. And Jane and Larry, just for my record here, your last name is?
Nick Law.
Thank you. I'm sorry to report that the electricity is still out in Montpelier, apparently for most of the areas where we are here in the city. Aaron or Greg, could I prevail on one of you, please, to just make sure that we have the list of folks that I believe Annette put in the chat function on Teams, so that we have a list for our records?
I have it. I'm taking notes.
Thank you very much. I want to thank those who made public comments along these lines about gravel pits and quarries. I'll come back to that in a minute. I just want to be sure that is there anyone else from the public who would like an opportunity to speak on agenda or non-agenda items at this meeting?
Yes, Mr. Chairman. My name is John Brabant. Sorry for the confusion. I do work with Annette Smith for Vermonters in a Clean Environment. I just would like to briefly, for the record, read to you a press release issued by none other than the Vermont Natural Resources Board. I'm sure you're familiar with that entity. It was a press release issued June 29th, 2009, and it's in regards to a Pollock Gravel Company to pay $19,000 in fines for multiple violations. I'll read it to you briefly, just so you can hear what went on then, and it's got some relevance to what was just testified to now. This was released by Mark Lucas, who used to be your Associate General Counsel. A Pollock Gravel Company has been fined almost $19,000.
John, sorry, you were breaking up at the beginning. I think maybe somebody else had was unmuted. If you could maybe start from the beginning on the press release, I think that'd be helpful.
Okay.
And if you're not speaking, if you could please mute yourself.
Okay, this is a press release issued June 29th, 2009. Mark Lucas is the contact. He was your Associate General Counsel at the Natural Resources Board. And it's in regards to Pollock Gravel Company to pay $19,000 in fines for multiple violations. I'll read it to you, and it's relevant to today's discussion. A Paulet gravel company has been fined almost $19,000 for multiple Clean Water Act and Act 250 violations. A joint enforcement action by the Vermont Agency of Natural Resources and the Natural Resources Board found that Rob Lee Farm, Inc. had expanded its quarry, this is a gravel quarry, without an Act 250 permit and failed to obtain proper federal and state stormwater permits for construction and winter work. Rob Lee Farm owns a 300-acre quarry with 2 excavation areas in both Paulet and Danby. In the environmental court order, Rob Lee Farm must provide $18,600 worth of gravel to the Poultney Meadowy Natural Resources Conservation District under Vermont's Clean and Clear Better Backroads program for projects involving the correction of road-related erosion problems in the Poultney Meadowy watershed in Paulet. In a related case, a co-operator, Jim Sheldon, excavating its typo, reached a separate $8,650 settlement last fall for not obtaining an air permit for its stone crushing plant and violating its Act 250 permit. I just wanted to bring this to your attention. This operation, a gravel pit, I think with some irony, has an Act 250 permit because it's gravel. There was a political decision. I was present at the State House when this bill was under consideration to exempt rock quarries, actually slate quarries in particular, from Act 250 jurisdiction. It was then State Representative Kurt McCormick, who was the representative at the time from Rutland, who advanced that. He was also chair of the House Natural Resources Committee. And because of his position and actually his environmental record, he was able to move it through without much opposition. It was a totally political decision and had nothing to do with the environment. It was about pleasing his constituents, and it went totally against the grain of what Act 250 sees as important to regulate. It makes no sense that one would regulate a gravel quarry and not a blasting style quarry such as a slate quarry. The other thing the reason I wanted to read this into the record is that this entity, Rob Lee Farm, is a repeat offender, and there's a pending enforcement case, as I understand it, and it's important that the intent of the Uniform Environmental Enforcement Act be followed. That is, repeat offenses are taken into serious consideration when formulating penalties. I want to also draw your attention to what I consider as a former Agency of Natural Resources employee who performed many enforcement actions. There's a record of my involvement in many, working both with the AG's office and Act 250, as well as our Office of General Counsel. The ineffectiveness when we allow, in lieu of penalties, in-kind services, or I forget the name of it, but in lieu of financial penalties, in this instance, the quarry, who for free manufactures gravel, donated $18,600 worth of gravel. So their out-of-pocket was $400. And I think in real time, we're now seeing how ineffective that approach, that public policy approach, that in lieu of penalties, they're called supplemental environmental program alternatives to paying cash penalties. They're a joke. So they get credit and slaps on the back from their buddies who might not even have supported your environmental action. And they pay $400 in penalties. You can see how well that worked. It provided no disincentive. They have no excuse in terms of their ignorance of the law or ignorance of impacts off-site. So I just wanted to put that on your radar. This, in sum, underscores the need for not only the citizenry to be heard at the legislature, but for this program, your program, Mr. Chairman, to get behind the effort that VCE and the citizenry of Vermont have been pushing to amend Act 250 to again regulate slate quarries so that they are on an even footing, at very least from a business standpoint, with all other businesses of this nature, and so that neighbors don't have to put up with this kind of nonsense without any, any regulatory authority or to attend to this. So that's it. I'm off my stump, but thank you for your time. I really appreciate it.
Thank you, John, for your comments and your input. Are there any other members of the public who wish to make comments?
Mr. Chair, this is Annette Smith. I just want to thank you very much for taking the time, and I want to thank the other board members for listening. I have no doubt that this is a small sample of neighbors of quarries and pits to operations throughout the state. I hope that this has made an effective statement to you about the need to do something to protect people and enforce so that this does not continue to happen. Thank you.
Thank you, Annette, and thanks to all of you once again for bringing your concerns to us and for making your comments in the manner that you made them, which we greatly appreciate. And on behalf of the board, I want to emphasize that we take these comments seriously, and that you certainly have my commitment that we will carefully review both what's in and what's out of Act 250 jurisdiction. To some of the comments that came at the end from John Brabant, how the permitting process is working with respect to these kinds of operations, and the enforcement of
our laws.
violations
I think
that we determine are serious and have strong basis in fact, and we will and I will endeavor to keep the entire board apprised of the results of that review. So thank you again for your comments and your input, and we will, as I said, we will proceed with a much better understanding of the seriousness and the widespread concerns that you have expressed. Okay, with that, I'm going to turn back to our agenda, and